So I only want this to be a quick video and not go on for ages, like, half an hour. I just want it to be like 5 minutes. Lammy, right? So this jury trial thing, there's got to have been loads and loads of people complaining to Lammy and the government about it. I mean, so this report here a few days ago claimed that there'd been a rebellion in Parliament to do with some of the Labour MPs and they weren't going to support Lammy on it. Surely things that have an important constitutional impact have to be voted on by the whole House, right? Jury trials has got to be part of the Constitution of Magna Carta. There were already questions over, was it lawful when the government altered the Charter of the Forests, because the confirmation of the Charter says that the Charter of the Forests cannot be altered, and neither can the Charter of Liberties. And then Magna Carta, which was 1215, and then I think 1225, and then 1295, or was it 1297? But the confirmation of the charters was 1297. Magna Carta, there was the first one, then it was repealed, and it was like reaffirmed, but then it was put into proper law as a proper act around 1295. And then 1297 was confirmation of the charters, right? When you read upon the internet, everything that you type in says that the confirmation of the charters says that Magna Carta's got to be kept, no matter how you ask it or type it in. Now, this is the thing. What the government have done in the past clearly is not lawful, right? Because it says that it has to be upheld and kept and cannot be changed and is in perpetuality, right? They're taking more action to uphold the EU law, which only came into effect in our country in 1998, and challenging whether it's compatible with EU law in the courts, like even things that Suella Braverman did, or Priti Patel did, or Shabana Mahmood has done, and now Lammy's doing this, right? They're letting them challenge it in the courts and letting judges decide that it's not compatible with convention rights in EU law. But they're saying that everything that Parliament does is privileged, yet it clearly can't be unless they wouldn't have acted against Shabana Mahmood for a Schedule 2 alterations for prescribed groups, right? Now, but because our constitution is not EU law, the courts aren't supposed to even mention anything in Parliament. The courts can't decide on our constitution because they can't make and change the law. So they've currently got it. So if it's something to do with one act of law that the government made to do with convention rights in EU, it can be questioned and challenged in the courts and then complained of back to Parliament by courts, like they did with this prescribed groups. But they're saying that we can't do that about what Lammy's doing about justices in the courts, right? Which is ridiculous. We had like this Seditious Liable Act, which made it so that if anyone was pursuing getting the law changed or the constitution by unlawful means, then a justice actually, could call on the documents to be taken down. That's a little bit like challenging EU incompatibility rights. That act was repealed in England, but it's still in effect in Northern Ireland. It sounds like it's protecting the Constitution, but our Constitution hasn't been protected. Now, the thing is this, right? Those jury trial rights in Magna Carta are still in effect anyway. It hasn't even been repealed in Magna Carta, so those clauses are still in the law anyway. So it's all about what do they mean. Now, there must be a lot of people complaining into the government, to Lammy. There must have been a mountain of complaints. I don't know if anyone's submitted paper petitions about it. A lot of people, there was 1 or 2 e-petitions knocking about, but remember they reject a lot of the e-petitions and don't let people publish them, right, on the same subject. There was a weak and feeble petition about the jury trials, right? There's meant to be... Tim Crossland runs that big campaign group to do with Defend Our Juries, who are outside the courts all the time, right? But all they do is sit down with signs and, try and not get arrested about protecting juries. I don't actually see them bringing any cases like Tim Crossland that is against convention right. It's actually against the constitutional right. Now, the thing that needs to be said and spoken and put into this video, and what people need to know about on a wider scale around the country, the general public, which definitely is not going to get talked about because all these talk shows like GB News and Talk TV and all these big channels with big hard hitters like all these You know, people have got millions of people following them now, and they're just not saying the right things. You know, Andrew Bridgen, you know, Farage. Then you've got like Tommy Robinson. You got that Paul Thorpe guy. Loads of campaign groups who've got thousands of followers, if not millions. Big Brother Watch. They can request that people write into the government in the hundreds and thousands in letters. They could even tell people to write them in official petitions in paper, just each person, and then they could get like the number of petitions on the session of returns up, you know, going from like 100 to 300 or 1,000, or get some kind of spike in that. People don't realise it goes into the votes and proceedings, right? They think that, oh, it's like, you know, e-petitions, it's kind of like a lot of nonsense, and they might get a debate out of it or a response, but if they write it on paper in the proper form, it goes into votes and proceedings, and it's on the historical record, right? Now, this is the thing with Lammy, right? What's the current situation now? I think most people think the current situation with juries is this, that you don't have juries in a magistrate's court for petty sessions, and we haven't really ever had them anyway. They used to have them in like private houses or pubs, and, you know, they just got like the magistrate in there, and you never had a jury anyway with a summary, right? And they've always just had them when the circuits come around your area, or if you've got a corporation or whatever that's got a mayor and alderman, which is a court of record, right? And they call a jury in, like in a William Penn trial or whatever, and they think that's it, and they think, oh, we've still got them, and we've got a right to them. But that's actually not the whole story and the truth. The fact is this, right? So we've got this, that Assizes of Clarendon. That Assizes of Clarendon was the first proper grand jury, right? And it's the grand jury is meant to be, you know, these lawful people who've been called and sworn in. They were meant to be like, you know, trustworthy, affluent people, right? Not just like anyone, but it's meant to be, they're meant to actually look into the matters and investigate the matters, and they're also meant to, like, you know, look at the evidence and facts and see if there's a case for an indictment, right? Now, I don't think that we're supposed to get those mixed up with the sheriff and the bailiffs who actually operate the cells, the sheriff counter, the, you know, affairs of the county, like dealing with elections and, you know, ceremonies and declarations and all that stuff. You know, you've got town crier. The bailiffs who actually, you know, operate the prisons and lock people up, or those trained bands who went round and, you know, could apprehend people, because obviously, and then you've got hue and cry when the people had to help to apprehend criminals as well, which, you know, I don't think elderly people or young 4-year-old children are expected to do that. That's why you've got sheriffs and bailiffs and under sheriffs and constables, right, to do the handiwork, you know, to do the rough work, you know, the grabbing hold of and apprehending. It seems like it was meant to be the grand jury, really, was meant to go have a view, right, and look at crimes and offences. But obviously after Robert Peel invented the Met Police and reformed the police, and then he starts inventing all these inspectors, detective constables, blah, 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 and it all becomes uniform and under a chief officer, and it's a military rank-and-file regime under officers, right? And then they've got investigators, and then, you know, like, as technology progresses, they've got fingerprints. It's all dealt with by the force and the police force, right? And then that doesn't give the grand jury much of a job to do, right? So then the police are determining if there's enough evidence or not a randomly selected, impartial body who are put together when the courts come around, right? Who actually even, you know, necessarily... Well, the police do know the area and they do know criminals, but after a while, the police get a complete and total monopoly on crime, and they get ingrained and permanent, and rather than having, you know, fresh people chosen every time the court comes around, you know, to look into cases, even, you know, people are going to know the area if they're from the area and get chosen randomly, but have that added impartiality, right? And you don't end up getting these regimes, definitely not a military regime, because it was never meant to be a military regime. It's meant the investigating offences is not meant to be the army. It's meant to be actually the public, the people, the citizens. Now, I know that normal magistrates are voluntary, but they don't. A lot of them are really incompetent in the law, And they're not required to have the law. The first law they should have made is that all normal magistrates and judges must be actually have a legal qualification, because then they wouldn't need the legal advisor. That it's a bit of a joke at the moment when you go into court, because they don't actually know the law, and that's the greatest crime against humanity is magistrates aren't actually qualified lawyers or king's counsels. That's probably the greatest crime against the people. But with these other justices who are legally qualified, who come around on the circuits, and then they call so you were meant to have both, right? You have a grand jury and petite jury. Now, the grand jury are supposed to really actually be like the police investigation, right? And the petty jury actually make the verdict. And they used to be able to be on both, because the petty jury, you could have been on both, but then they made a law so like the grand jury can't be on the petty jury, right? Now, the grand jury was still in effect up till I think it was 1933 off the top of my head, right? But by the time it got to 1933, it was purely like they were just wheeling them in, getting members of the public, voting them in, wheeling them in, and like, all right, sign this off. The judges just wanted them to sign it off to say that it had been properly investigated, right? Because I think the police had, by 1933, this is like we're around Ethel Margaret Self. Ethel Margaret Self, with a dangerous driving charge at Lowestoft, she was from Longstretton below Norwich, right, in East Anglia. She just missed her, although I don't know if it was an indictment or not. I don't know if dangerous driving was an indictment under that 1930 Road Traffic Act, whatever it was. If it was, I'll have to check whether it was an indictment or not. I think she got dealt with by petty sessions, but if she could have appealed it to a Crown Court or to the Quarter Sessions or Assizes. They can't find the records. I've asked them to look for them. They've looked for them and they're not there actually for that case. We've got the petition from Parliament on the record, so it did happen. Not just a newspaper story. So but if she'd have appealed that, maybe that's why she didn't appeal it to the Crown Court, because they got rid of the grand jury. Now, she actually could have appealed to the Crown Court and got a grand jury, but she just missed it. It was 1936, so 33, 34, 3 years. She'd just missed it by 3 years, right? So she wouldn't have got a grand jury if she'd appealed it to the Crown Court. She would have got a petty jury, but not a grand jury to check the legitimacy of the evidence. And that's what actually Ethel Margaret Self was complaining about. She was saying that the charges or the accusations were not, it wasn't her. There was just fake or false accusations. I don't know whether it was the wrong vehicle or whether she wasn't driving, but why I don't know who would come forward and confess it if it wasn't her, but it was the integrity of the charge she was bothered about. So she would have been, that's something that would have been in a, if you lived in 1936, that's a big thing, getting rid of the grand juries in 1933. I think they had some of them, but extremely minimal. They got rid of it as a big thing. But she would have got a petty jury, but, but they weren't doing anything. Because by 1933, you've already got a proper, well-established police force. In fact, when she wanted to go around and see the Minister of State in Cromer, there was police detectives knocking around there trying to stop her from seeing him, right? This is the whole model for this. Is the police getting insidious? Is the police part of the industrial military complex, right? I actually think now that what the Crown Prosecution Service are doing, and you see, the police are investigating away enough evidence, and the Crown Prosecution Service are. We're paying two authorities to do a job, so we're having to pay for it twice out of the public purse, right? When actually it was going to be they were called in on duty, the public are called in on duty on service, right? To look at it, but purely impartial. And I might say, well, the CPS know the law and they're qualified and they've got all these directives they've got to follow. They don't follow them. I know they don't follow them. They haven't been following them for our political rights at all. They pretend they've got a frontage, a front shot presentation to the public that's squeaky clean, it couldn't be more polished and squeaky clean, and the good touches of the whole country, right? They deal with very hardened criminals and serious cases, right? These people, CPS, are supposed to be the most trusted people in society and super squeaky clean like Keir Starmer, right? But that's not the truth. They're completely and totally corrupt and insidious and evading all corruption within its own authority, particularly in our political causes when they're the ones who are meant to be called into Parliament, right? On contempt, which they've been evading since 1986, and then they send, even when they sent Patrick Gibbs in, the barrister, to do their dirty work for them with Lord Hanningfield, he never even gets called into Parliament for contempt when it's clearly obvious that he did it, right? Even when they do it in broad daylight with 20 spotlights on them, right? Patrick Gibbs is not getting called in for contempt, right? Which is ridiculous. We're not actually meant to be paying for the CPS. We're not going to be paying for the CPS, and we're not going to be paying for the police, right? Except to, open and lock jail cells and be rugby players to go around and punch people in the face in North Wales, right? On someone's front lawn, right? When they grab hold of them and they never get prosecuted for it, right? And, maybe forensics and fingerprinting and things like that, right? It's meant to be impartial and it's meant to be the public, and I would have said it's meant to be voluntary, right? Or it's part of being a citizen in this country. I mean, Lammy says he reckons that his funding, he's trying to cut the funding down and there's a backlog of cases, right? I think that the Crown Prosecution Service, we've got all these police forces, all these detectives are meant to be checking and weighing up evidence and getting it. Then after they're doing it, then the CPS are doing it again, right? And then you send a barrister in. Like Patrick Gibbs, are paying for a barrister as well on top of that, when actually it's going to be the police, go arrest someone, fill in the forms, there's a case of evidence, the grand jury is supposed to look at it will voluntarily and completely impartial to look to see if there's enough evidence to prosecute, then they sign it off, and then they send Patrick Gibbs in to prosecute because he's a barrister and he prosecutes on the freaking evidence, right? But now we've got, armies and armies of solicitors and armies and armies of police with no impartiality at all whatsoever, right? In fact, they've become they're military, right? And then they're not even wanting that. They're hoping and planning that eventually everything can just be like some drone following everyone around and spying on everyone, and then automatically you get filmed with facial recognition stealing a chocolate bar, and it goes through a computer and you're identified, and it sends you a letter in the post, and you have to turn up in court, and then you have to fucking prove to a court that it's not you in the photograph or that you didn't steal a chocolate bar. And you're lucky even if you get a fucking, an actual judge who's not qualified in a magistrate's court for law, right? You might as well just have a fucking robot there, like one of those, little Santa Claus guys outside a cobbler's shop, like a little, the little cobbler fucking doll thing, just hitting the hammer down, a real robot hitting the hammer down, repeatedly, next. Might as well just have a machine just hitting a hammer down like that, and then you just stand in front of it, it just hits, bang, just hits the hammer, and then the next person comes along the conveyor belt, bang, and it's, you're sending them off to prison on a conveyor belt, right? So the grand jury, this Magna Carta right to your peers is actually meant to be the right to the grand jury assessing the evidence as much as the jury making the verdict, because the whole thing is your peers are the people who look at the charges and allegations and see if there's a solid case, randomly chosen peers from the area, and investigate it and make the verdict in the petty jury as well. But what we've got is the police investigating it, who are a rank and file regimed under a chief, constables, arrows on the arms, pointing downwards, detective constables, chief detective constable, inspector, DS, DI, whatever, right? And the CPS, who are under a chief, and then an attorney general and directors of prosecutions and all that, fully militarised, right, in rank and file. And they're not impartial. The police don't even speak with the same accent as us. They're not our peers, right? Was as reasonable. The suspect walked around the corner at approximately 7 p.m. on a Tuesday, and he was armed with a reasonable amount of cooking implements, and it's if you record, right, who's my peer, right? I'm from Yorkshire, right? I am from Yorkshire. Not, hello, sir. It's good morning to you. I mean, I can't qualify for going to private school like David Cameron, or someone like that. I am not from a private school. And I'm not a member of the House of Lords, although Lindsay Hoyle is meant to be Commons. Lindsay Hoyle, I could pass off for a Lindsay Hoyle accent, but he's only Commons, right? He's not, he isn't a Lord of Baron, right? Now, the police, right, don't talk like me, right? The police talk like they are a peer group. Right? They're not like, it's like if you go to a private school, right, and you come out like David Cameron, right? Even though, well, David Cameron is a baron of the realm now, right? But, he's upper class, right? He's not necessarily peers, but, all of those, that's what the Clarendon Assizes sort of said, didn't it? Well, like, they didn't have vagabonds on those grand juries. They had kind of like respectable people who owned land in the area and certain things like that. So in a way, but really, the police, when you get police coming out of college, they come out of it like when you come out of private school with a different accent, right? They aren't your peers. They've come out of police college and they've been trained, and they've taken and adopted on their own accent, their own peerage accent and language and way of talking, right? So that they're not actually our peers. They're not normal commoners, common folk, right? They are of a different peer class to us, right? That they're police. So I actually don't even think that we're being investigated and adjudged by our peers either. Now, what Lammy's... So the whole thing is meant to be the grand jury investigating crimes and the petty jury making a verdict. Obviously, you've got a judge there, a convener, the King's Justice going round, right? But when they got rid of the grand jury, there should have been alarm bells ringing then, right? And now what we're only left with is a petty jury, right, on the verdict. Not even the investigation part, and they're definitely not selected at random from the public and impartial. They're militarised, right, under Robert Peel. So what we've got left with now is ridiculous. And then they say, no, they're not allowed to look into the law, or they can't check on the legislation, even though it's legislation.gov.uk. It's pretty much the legal advisor's fucking computer. We're not asking them to go look at some dubious Sir Edward Coke book that had to be rewritten by William Prynne or something, right? We're talking about stuff that's on the wall at the court, right? It is the right of the jury to decide with their conscience. If the jury can't look at that and read it, it's like the legal advisor putting advice there, right? I think they're lying to us about what the jury can and can't look into, and the CPS advice on it. And I think that the jury are already being completely obstructed from doing anything and groomed. Well, actually, there were it was two separate juries, wasn't it? There was the grand jury and the petite jury who had different functions. So, but I think the petite jury is still supposed to know people's rights, like the jurat oath and the alderman oath and certain other oaths, like they're meant to uphold the rights and liberties of the people, right? And when the jury's picked out of the random public, if you, like I said earlier, if you've got public or private business to Parliament, public and private bills, it's going to be promoted in the newspaper, and everyone in that community is meant to know about it. I'm not saying that you expect them all to buy the newspaper, but the legal basis behind it is that the legal theory and basis is like every single citizen needs to be informed of that public and private bill in Parliament, so whether they can oppose it or not. Now, if they're choosing the random jury from that area, right, and they've seen a newspaper advert, that people are opposing the ULEZ in a private or public bill, right, whatever you want, and then they go into the court, and then they read the name out, and then the jury are like, hey, just a minute, and then I hear about that in the newspaper. Are you the guy who's doing a private bill to Parliament, or the public bill, right? Oh, isn't he? Just a minute, Your Honour, I think this is parliamentary business, so I'm not supposed to be hearing it in this court. Have you got leave? That's maybe what the jury are doing now, but because they're turned into amoebas and completely and totally blocked off, right, that's not happening. And now when we've got Lammy, he wants to get rid of the petty jury. Let's not call it a jury, right? Let's call it a petty jury, right? Lammy wants to get rid of the petty jury, right? Now, is there even a right to a grand jury, right, under Magna Carta? One way I don't even have them anymore, but is there a right to, if you really want a grand jury and demand one, have you got a right to one under Magna Carta? Does Magna Carta say that you've only got a right to a petty jury, right? Just scroll back up here now. Because there are certain acts still in force in Northern Ireland that say that, it's a serious offence to try and get rid of the Constitution by unlawful means. But, was it lawful means to get rid of the Charters of the Forest and change it or modify it when the confirmation of the Charter says that you can't do it? No free man shall be taken or imprisoned, right? Well, that doesn't necessarily is add in prison because, basically, when the police say they're going to charge you and they put you in the cells, right? That's being imprisoned at that point, then, right? Or dissented or exiled, or in any way destroyed, nor will we go upon him, nor send upon him, except by the lawful judgment of his peers, and by the law of the land. I don't know why they've put this "and" in, because this is the whole thing with Ian Bray. Can it be by the conscience of the jury purely, or does it have to be only purely in legislation or not? Because that was the whole issue around the William Prynne, and also the fact of whether or not they actually even were doing a matter to the either House of Parliament or the King as well. But so I wanted to look at the French version of this. So this hasn't been repealed, so there's no issue with they repealed it or modified it. It's just the interpretation of it, right? It says lawful judgment by his peers, but the grand jury, when we say judgment, does that mean the verdict and sentence? Or whether they're guilty or not? Because the grand jury were meant to judge. It was judgment on if there is a legitimate case or not, or a substantial case for indictment, right? And if not by that, then by the law of the land in front of a normal petty sessions magistrate, if it's only summary, right? I am starting to wonder if this was if they only ever had summary or indictment from the start, then surely this is the differentiation that by the law of the land is by summary, right? And then by judgment of his peers is if you're indicted by the judgment of by the grand and petty jury, of which now we've only got the petty jury, right? They're trying to make out that you can have it by the law of the land or by your peers in a magistrate's court. And they're trying to make out that, that doesn't mean the difference between summary and indictment, where summary never needed your peers, etc. Or you've always got, you have to can appeal it or whatever. So I wouldn't actually mind seeing the actual French of this, the actual French version. But Graham Moore is of the strong opinion that, the law didn't have to be applied necessarily anyway, and it could be purely by the peer judgment on whether they think the person, committed a crime on their conscience, whether they want to acquit them, sort of forgive, like an element of forgiveness. You know what I mean? Like an element of forgiveness. It provides that you can be forgiven because if you truly believe that you didn't commit a crime, regardless of what the law says, or you didn't mean to commit an offence, or you didn't think it was, or whatever, you can be acquitted. But some acts say that you're still a criminal whether or not you intended it or not. There are all these offences that, some offences, if you didn't really mean to do it or believe that it was a crime, you aren't a criminal. It's not an offence by law. And others, even if you didn't intend to commit it or mean to commit it, you're still a criminal because it happened, right? I want to find the French. So this is the actual, this is the French here, right? This is the original French for Article 39. This is the exact, the original 1253 Magna Carta was written in Latin, not in French. Oh, well, I was wrong about that. I thought it was French because it was the Normans. It's written in Latin. So this is Latin. So this is meant to be a really good Latin translator. No free man shall be taken or imprisoned or deceased or outlawed or exiled or in any way destroyed, nor shall we go upon him or send upon him except by the lawful judgment of his peers or by the law of the land. But this is a thing, right? If you and me are going about sort of like, for example, right, doing a petition, right, and we're collecting signatures, the police aren't allowed to go upon us. They're not allowed to go upon us because we're protected by parliamentary privilege, right? So they can't go upon us, sent upon us without the lawful judgment of our peers or by the law of the land. Well, the law of the land stops them from immediately acting against us, right? It's not lawful for them to arrest you. It's not lawful for them to imprison you. It's in detention in a police station. It's not lawful for them to actually arrest you or put you in a police station or intervene in the proceedings, right? That's the law of the land, in effect, right there, right? Now, if you end up getting imprisoned and it's against the law of the land, then you get a judgment by your peers, right? But the law of the land is meant to protect you there and then, right? Now, what happens if you are... if you kick your football, right, over into next door's garden, right, and you go to collect your football, which is your property, and the law allows you to enter that property to collect your football because it's your property and you can retrieve it, but only to retrieve the football and come back. That's what the law of the land is, right? Now, let's say that you go to get the football and the person who owns the house calls the police and grabs you in his garden and gets hold of you, and then the police turn up and you say they're trespassing, and then the police arrest you for trespass and takes you to the police station. Now, that you were actioned upon, you were set upon, and you were taken, and it was not according to the law of the land. Because the law of the land said that you had a right to take that football and you shouldn't have been grabbed. Right? So, by the law of the land, you wouldn't have been arrested or happened upon. So, they won't go upon you by the law of the land or judgment by your peers. But you end up getting judgment of your peers if the law of the land wasn't applied. Right? Now, this surely should blow up David Lammy's brain. David Lammy's brain should fucking explode and go, what? What? You can't be serious. You know, like on Total Recall, you know, when like they're fucking on Mars and all the oxygen's like fucking evaporating. He's going, ah, like that, right? Get a steel rod, right? Get a metal rod, right? A steel rod, 3-inch thick, and just bend it in your hands like Incredible Hulk, like a mind bender. Because David Lammy, right? His mind would explode if he fucking understood that. Because that would mean that what he's doing to get him into those jury trials is absolutely fucking insane and nuts, right? And even if you take it into a modern context, like you're driving down the road and you set up a speed camera and a fine comes through automatically, and if you don't pay it, like they, send an automatic process to fine you and then double it or whatever, and then, they just put your points on your license anyway, and you never went into a magistrate's court, right? It goes to a justice. There were no people there. And, what I'm interested in, there's no jury there, right? And, the magistrate, you don't turn up and the magistrate just, prosecutes you. There was no peer judgment or anything. Gets put on your license. You've been convicted, right? But that was apparently according to the law of the land, and they didn't have to have the judgment of your peers, right? But it's all right when they want it to work for them, right? But look, according to the law of the land, in another instance, like it should go into effect for you not even to have an action or process against you. That's why you have your peers there, because they've got to look at it and see if it was a lawful process, right? I really think that we should have it even for summary. I think that they should have it for summary as well. I'll try another translator, and there's no "and" in there, that's for sure. Here's another Latin translator. This one has a charge on it. Here's a different one. That's not done what I wanted it to do. So it's pretty much coming out with the same. It's pretty much coming out with the same when you do it from Old Latin. So it actually is saying that the Assize of Clarendon 1166 is widely recognised by legal historians as a foundational moment in England where the procedure of indictment was formalised and separated from the immediate final judgment, establishing a two-stage process, right? So that grand jury in Clarendon Assizes, I think, really is properly where it separates an indictment or not. 1166, so it's not even that long after the invasion. 1066, 1166, that's like only 100 years after the conquest. 1166. So that Justices of the Peace Act 1361 established the modern magistrate system by authorising the appointment of worthy individuals in each county to arrest, restrain and punish rioters. But that's still quite a while after that Clarendon Assizes. I already knew about that Justices of the Peace Act 1361 because it's on the legislation website. I don't think there's much to it. Again, this is like, is that Latin or French? I think that's French. There's not much to this. There's only a paragraph. First, that in every county of England. All right. So this is actually, they had that Clarendon Assizes, right, and that really makes the indictment separate, really, from summary, because you don't have the indictment and a grand jury, but that wasn't necessarily that they have it everywhere. So 1066, 1166, 11, 12, 13. So you got another 200 years. You might not have had it everywhere. And then you've got Lancaster and Durham and all that. First, that in every county, so they might even not have had the same judicial system everywhere. Like in cities and towns and ports, they had commissions and all different types of charters and things doing different legal processes, right? And formats and models. First, that in every county of England shall be assigned for the keeping of the peace one. All right, so this is even getting your lords in there. One lord, and with him 3 or 4 of the most worthy of the county, right? With some learned in the law. But they were saying that even the word baron, knights and barons, this is all to do with William Prynne as well, when they were, what even is the Parliament and the forming of the Parliament and what originates in the Parliament, the prelates from around England, and then they were holding these great councils that weren't parliaments, and all the lords, well, the knights of like the Conqueror and so forth, weren't called to what they call parliaments. It was more prelates and abbots and bishops, and then you're looking at what you're getting into William Prynne and what even formed Parliament when you're getting into when you've got like way back here 1200s 1300s for even who are lords and barons. This is after 12, so this is after 1215, and then we've got 12 by the time they actually made Magna Carta into the proper law. So they've got Magna Carta. They've got that Magna Carta law that you can be judged by your peers, 1215. And then the Clarendon Assizes were before that. So they had the indictments before Magna Carta separating from normal summary. And then Magna Carta made it that you got a legal right to have that. So surely that's got to be the difference between if you're going to have a grand jury or not, or if it's just going to be summary, right? Surely, by the law of the land, or by his peers, if it's by an indictment like in the Clarendon Assizes, right? Surely. And then that's the difference between the two, because there's two distinctions there, and that's chronological order. Clarendon Assizes makes it two separate processes, so you have grand jury or you don't. And then after that, you got Magna Carta, which says it can be by the law of the land or by your peers. So surely that's when you're having the peers is when you're having an indictment, right? And surely by the law of the land is when you're not, or if the law of the land protects you from having legal action because they shouldn't even be bringing it in the first place, right? Like in my earlier example. Now here we've got the next stage, or a substantial next stage that is worth mentioning. And I don't think there are that many really important, significant acts in between this and Magna Carta, really. First, that in every county, there's only one paragraph: England shall be assigned for the keeping of the peace one lord, and with him 3 or 4 of the most worthy of the county, with some learned in the law. And they should, well, the magistrates still aren't learned in the law. Magistrates still don't have to be learned in the law. So, can you believe that we've got to the year 2026 when magistrates still aren't learning the law? They need a legal advisor. That's got to be the greatest crime against humanity. And they shall have power to restrain the offenders, rioters, and all other baritons to pursue, arrest, take, and chastise according to their trespasses or offence, to cause them to be imprisoned and duly punished according to the law and customs of the realm. And law and customs, not just the law. It says punished according to the law and customs. So this is another thing. In Magna Carta, when it says judgment by your peers or by the law of the land, you could this is like, you don't even have to be by the law. It can be by custom. So no wonder your peers might have to decide it and not the law, because you might not be there on account of the law. You might be there on account of breaking the customs, right? How can Lammy, I'd like to see Lammy's example for that. Maybe Lammy's breaking the customs now. Maybe what Lammy's doing now are against the customs of the realm, and we want him in front of a court, even though it's not according to law, right? How could he wrap his head around that one, right? And arrest does that all that they may find by indictment or by suspicion, and to put them in prison. Well, that's a suspicion for a crime that's indictable, right? Right. I will put some money. I will put like £1,000 on the table now to David Lammy, right? I bet David Lammy £1,000, right? The indictment by suspicion is suspicion of offence which is freaking indictable, right? Indictment or by suspicion of an offence which is indictable, right? And then to put them to prison, right? So this is for an arrest all those that he may find by indictment. So that this is for the grand jury, and to take them all. This is when you get put in the Gaol, by the way, as well, and be of good, not of good fame. This is like the reputation as well. This is why, to do with like the people in the local area. They shall be found sufficient surety and the money prize of their good behaviour. This is like, on parole, you get people to sign a petition on parole for your good behaviour. I've actually got an exhibit, an example of one of those towards the king and his people. Oh, by the way, that's the people who invaded it like 200 years earlier, right? Taking over the whole country, even though there's like resistance in Ireland and Scotland. And the other, duly to punish to the intent of the people, not be not by such rioters or rebels, trouble or damaged, or the peace blemished. So like this is what Edward Cook said. What does it mean, the breach of the peace? Not to be endangered or the peace blemished. So it means the king's. I think that means the king's peace, but also the king's peace was the king's peace was something anyway. Unlike you got the right to travel on the roads, the main highways of England. That was one of the king's the four roads, travelling on the king's peace by being unhindered. That was breaking the king's peace. If you travelled on the main roads and got unhindered, it was a breach of the king's peace. That's travelling without being impeded or obstructed, and without having to be charged or fined on the main trunk roads of England, those four main roads. That was one of the king's peace. So that was a breach of the peace. Not just like if you think someone's in the road, like, making a noise or shouting, or someone's having a party when you're trying to sleep, it's a breach of the peace, right? It's in a town or city after hours. Being fined or obstructed on the highway, right, was a breach of the king's peace. That was one of the pieces. There were the different king's peace, right? Infringement to people by such rioters or to be troubled or endangered, not to. Oh, it just passing on the highways. Look, I hadn't even read that on this, and I'm right about it. Blemish, no merchants or others passing the highways of the realm disturbed or in any way put to peril, which may happen of such offenders. Well, this is why the police reckon that if you're driving 2 miles an hour too fast, that you're putting people at peril. But I don't think you are putting them at peril on a main road that's straight when they've got the illegal signs on that it's 50 when it's national speed limit, right? Disturbed, I think that's disturbing us. That's harassing and disturbing us, right? For sure. I was about the king's peace on the highways. So breach of the king's peace could be for impeding people from travelling freely around the country on the main roads, like on the A1 or on Watling Street, or Ermine Street or Icknield Way. But Icknield Way is not a proper route anymore. I think this whole paragraph is about the indictment, because otherwise it's only going to be summary. And I think that when we've got an indictment, you do have the people. Justice of the Peace Act, 1361. Yes, sheriffs existed long before the Assizes of Clarendon in 1166. The office of the sheriff, originally known as the Shire Reeve, dates back to the Anglo-Saxon period, where before the conquest, Shire Reeve was the king's representative in each shire. Sheriffs held courts. The Assizes did not create the office, but rather heavily reformed and expanded its powers. It required sheriffs to work with juries of presentment to arrest suspected criminals and bring them before travelling royal justices. So it didn't expect the sheriff to permanently appoint an entire police force to deal with the presentments themselves and not have people randomly chosen from the public, like Sir Robert Peel, and have I'm under a military regime where they all do as they say by chief officer, and have them permanently employed for their lifetime job. It actually is supposed to be selected from the public at random when the courts come round, right? And now we've even got the CPS playing at it as well, right? And then we say, we'll scrap that. We'll have the public looking at the evidence. We'll get a full-time professional crew, right? And not even we wouldn't even need the brute squad to do the brute squad business, like we do everything, right? Now they want to get rid of the actual petty jury, right? You got to be kidding me. So that was part of the reform. Here's a good question for it. How did the Justices of the Peace Act 1361 change justice in England from the updates by the Clarendon Assizes? See what it's got for this one. What have we got for us now? I don't even like AI, but this is like, I'm doing a Howard Crowhurst now. I'm challenging it. The Justices of the Peace Act 1361 transformed English justice by shifting from a centralised system of travelling royal justices established by the Clarendon Assizes to a localised, decentralised and community-based system. What? No, it didn't, because they still had... That's not true. While the Assizes of Clarendon enhanced royal control by sending judges from Westminster to conduct inherent court sessions, the Assizes, the 1361 Act permanently assigned the local gentry in each county to manage law and order, creating a more permanent structure for local magistrates. The Assizes of Clarendon empowered inherent royal justices. To take up surety, it made a shift from largely reactive punishments of the Assizes in the 1361 Act empowered JPs to take surety of good behaviour. This allowed justices of the peace to bind over suspects, those not of good fame, to ensure they did not break the peace, acted preventive rather than a strictly punitive one. Minor offences. The Clarendon Assizes were focused on identifying and punishing major crimes, right? The Act and subsequent development empowered JPs to deal with a broad range of low-level criminal offences and berate as local troublemakers, so that's actually, I think that's more like getting more like, when they got a few good trustworthy men in the area, they're definitely not, so they're not talking about, so that Justices of the Peace Act 1361, that's like, nothing to do with the indictments and the travelling justices, right? That's like for the sheriffs and petty crime in the local area. They get. I think that's for actual, like the sheriff's got people to help him out and stuff like that. Because usually it would have been like the hue and cry and the people. I think this is setting up like I wonder how they were. How was... We need to know how it was being dealt with before that Clarendon Assizes. Before the Assizes of Clarendon in 1166, it's quite far back. We're nearly back to the conquest then. We're nearly going back into Anglo-Saxon with this. Before the Assizes of Clarendon in the 1166, the local legal system in England was primarily decentralised, focusing on local courts such as the Hundred and Shire courts and a powerful, largely autonomous sheriff, rather than the standardised royal assizes introduced later by Henry II. Justice relied on local custom. So I don't think this is before they actually had those circuits going round. This is before they had the circuits going around. So, 1160. So they haven't even 1166. They didn't actually have Magna Carta. 1166. Oath helpers. So they didn't. I don't think they had indictment or the circuits. I don't think they had the indictment or the circuits. And so the grand jury is specifically the right to a jury trial is to do with the circuits. It's on the circuits because that invented it. So the Clarendon Assizes actually invented having a grand jury and a petty jury anyway, right? And before that, you pretty much just got your hundreds courts, which follow on from Anglo-Saxon, with your shire reeve and the sheriff, and the local people on hue and cry for the offences dealt with purely by the local area, right? But then these criminals of great fame, infamous people, you get put in the gaol and have to wait till the justices come round. So that's what the Crown Court, the Crown Court is the grand jury, grand and petty jury. That's the point of it. That's what it actually is, because it didn't exist before then. That's what it actually is. Says here, yes, the formal establishment of regular organised justice circuits in England is widely considered to have started with the Assize of Clarendon in 1166. King Henry I reigned 1154 to 1189, created the system to centralise legal authority, replace local feudal customs with national common law, and provide more accessible justice. So the grand jury and the selection of it, both grand jury and petty jury, it is the circuits. And you get a justice coming round in order to call up the people together. So I don't know what Lammy's talking about in Magna Carta if you can have it without them, because that's what it is, right? You might as well say, I'm abolishing Crown Court trials because they're taking too long and there's a backlog, right? So you might as well... Lammy is about as legal to say we're not having a jury on the circuits as much as to say we're not having the circuits anymore, right? What's the point in them? Because that's the point. The point of it is to have the circuits going around with that system, which is what that system is. Otherwise, Lammy's about as lawful to scrap juries, and they're meant to have grand jury, not just petty jury, right? He's about as legal to do that as he might as well just say, because there's a backlog and because we ain't got any money, we're only just going to have magistrate. And the magistrates' courts now, you might as well just have everyone tried in the magistrates' courts summarily until the backlog's cleared. Because the magistrates' courts are empty. Look, right, I was following the magistrates' courts on on the website. They've got a website for all the court listings, right? Courtserve.com, whatever it's called, right? And when I sometimes go on there whenever there's a case that I need to look at, like Extinction Rebellion case or, Stop ULEZ or whatever it is. I look through all of them. I always look through the listings, right? And a lot of them on some days are very empty or there aren't many on there. Some days are really full. But what I found is that the magistrates' courts are not that busy, and there is a lot of foreign names on the lists. There's like 75% foreign names on those lists, right? And they're not always full. Yet they closed down like Chorley, Northallerton and Halifax courts, which were beautiful old-fashioned buildings with a lot of heritage in them. Really brilliant buildings. If you ever have to go to a court, you don't want to go to like Manchester Magistrates Court, like if fucking die of static, you like die of fucking, you die of boredom in there, waiting in there like some sort of kind of fucking, really horrible, nasty modern buildings that don't have any atmosphere or character to them at all whatsoever, right? Like, Halifax and, Bolton did as well, like Bolton, Chorley, maybe not that Northallerton one wasn't that old, but really terribly closed them all down. And now they're saying there's a backlog and they got rid of juries, but that's what he can't get rid of juries because that's what the assizes is. That's what the circuit is, right? The circuit is the assizes, right? I said I want to make a short video and I've been doing another 57 minutes now. It's going to be an hour. No one wants to have to listen to this, right? Lammy's breaking the law, right? And he's going against Magna Carta. Magna Carta was 1215. This is before 1215, all this, right? Although Magna Carta was before that Justice of the Peace Act, which has helped for the local courts, right? In normal, for normal kind of like... So the summary set up, for getting officers and people helping with that, right? I'm calling Lammy out on this because he's criminal. He's and there are acts of law to actually bring legal action against Lammy for acting against the Constitution, like that libel act. In Northern Ireland, they were to pursue the change of law unlawfully. Lammy's doing it unlawfully. He hasn't got the right to do it. How can it be that Lammy cannot get called out for breaking the Constitution or any misconduct in public office, yet when it's Shabana Mahmood breaking an EU law, like, what was only invented in 1998, and it's against the convention, right? You can get all the courts are in there, full guns blazing and getting them called out on it, and then, they're intervening in parliamentary processes, right? And then they won't say, oh, no, it wasn't an act of a public authority what she did. She was making legislation to affect her. I always still take action against her, right? I was actually defending Shabana Mahmood. These people, and then they would try to get this Assisted Dying Act through, totally against Article 2 of the Human Rights Act 1998. And that's new law. That's not breaking the old Constitution. They can't even uphold the new Constitution, right? What they're doing is criminal. And the assizes, the Crown Court, is the grand jury presentment to travelling justices, right? That's what it is. So you can't say, oh, we're taking away that from Crown Court case trials, because it's not the Crown Court then. Or it isn't what it is. It's like saying, oh, I'm going to go travel. I'm like, we'll go on a bus trip to Skegness, but not on a bus, right? Because I'd take the bus away, right? It's not actually the King's Justices just going around doing what they want. Is the King's Justices there summoning the public in the local area, like overseeing it? And I know that sometimes you can have a jury and sometimes not a jury, but they've already reduced it to that. It's from what it's meant to be. When they have the grand juries, we need to stop these people. We need to stop David Lammy now. He's not acting lawfully. They're blagging it, and what's evidence to prove that? How can you prove that? Because they changed the charters of the forest. It says that this act shall not be changed or modified, and last in perpetuality, on all points. But they take it away. It says it will last in all points. These people are the criminals. These people are the criminals. It's like an exhibit. It's like the museum, a night at the museum. And here we have, it's like, in Doctor Who, in the museum episode of Doctor Who, they become the exhibits. Here is David Lammy. Evil justices, ministers and councillors, like in the 1688 Bill of Rights. It's on display. It's like, it's like these people are almost coming forward to fulfil the role, to be. Anyone got a crown prosecutor anywhere? Oh, Keir Starmer, he's at the front of the queue. These people, I don't think that they quite understand, right? They're on exhibit, and I've always, that's how I've always felt, is that they're not the real deal. They're not the real thing. They're not like the real roles in society. They're like, that's why they've got a costume on, a wig, pretend. It's like, oh, when you school play, who's going to be the donkey in the school play? Who's going to be the king? Who's going to pretend to be this or that? They pretend, right? And now we've got these, who's going to be the corrupt justices, ministers and councillors. Oh, look, David Lammy, Keir Starmer, somebody like, now we're going to see a show. Now we're going to see a real show, an exhibit. Exhibit A, Keir Starmer. Exhibit B, David Lammy. How to completely and totally, destroy the constitution of the country and not follow the law to what it says that you can and can't do, right? Like, in Article 2 of the Right to Life and the Human Rights Act, that you can't have assisted dying because it's not a criminal process, it's civil, and you can't have that, right? Something needs to be done about these people, and we need to stop them on a national level. And, people are doing that now. That's why there are all these campaign groups and protests everywhere, and people have had enough of the Labour Party for sure. Not blaming just Labour, because, there was some dodgy, particularly from Queen Elizabeth from 1948, there was some strange stuff going on, like with the Magna Carta and changing the privileges and messing around with all that. Between 1948 and 1967, there was some questionable stuff going on for sure.